Good afternoon and welcome to the Berkley Center. I am Michael Kessler, Associate Director of the Center and a faculty member in the Government Department in the Law School. I'm delighted to welcome you all here today for a conversation with Cathleen Kaveny on issues arising from her new book, Laws, Virtues, Fostering Autonomy and Solidarity in American Society, which up until 20 minutes ago I had in this version and has appeared as of today in this version. And there's someone from the press, the bookstore, who's able to sell you one, and we have a sheet that I will pass out with some further information about this wonderful addition to the scholarship. So let me introduce you to Professor Kaveny. Professor Kaveny focuses on the relationship of law and morality. She joined the Notre Dame faculty in 1995 and in 2001 was named the John P. Murphy Foundation Professor of Law. She earned her BA from Princeton and holds 4 graduate degrees from Yale, including an MA, an MPhil, her JD, and a PhD. She's a member of the Massachusetts Bar and clerked for the Honorable John T. Noonan, Jr. of the U.S. Court of Appeals for the Ninth Circuit. Professor Kaveny teaches contract law to first-year students at Notre Dame, and she teaches in the Department of Theology. She offers a number of seminars, including with titles such as Mercy and Justice and Complicity, 2 separate courses. Professor Kaveny's new book, Laws, Virtues, Fostering Autonomy and Solidarity in American Society, which will be our topic today, is available as of now from Georgetown University Press. She has also published about 100 articles and essays in journals and books specializing in law, ethics, and medical ethics, as well as more popular venues such as America and Commonweal, where she appears on the masthead as a regular columnist. She has served on a number of editorial boards, including the American Journal of Jurisprudence, the Journal of Religious Ethics, the Journal of Law and Religion, and the Journal of the Society of Christian Ethics. She has been a senior fellow at the Martin Marty Center at the University of Chicago, 2002, where I first met Kathy and had many long conversations about these issues, and the Royden B. Davis Visiting Professor of Interdisciplinary Studies at Georgetown University in 1998. She is also a member of the steering committee of Notre Dame's Institute for Advanced Study. So we have asked Kathy to speak about some of the general issues that are raised in the book, and she'll take some time for that. And then after that, I will pose some additional questions based on my reading of the book, and then we'll have ample time for discussion among all of us. So please join me in welcoming Kathy.
Thank you for that very nice introduction, Michael. And it's always nice to talk to Michael because somebody else who has gone through the craziness of trying to do both degrees, trying to explain to somebody, nothing, makes you look odder to somebody than explaining to like a 7-year-old that you're in 23rd grade. They look at you like you're crazy, and you probably are. So it's always nice to talk to Michael because he understands what that is like. And I'd also like to say, I just saw the book for the first time myself 10 minutes ago, and I would like to really thank Richard Brown, the director of Georgetown Press, and all of the wonderful people he works with for moving heaven and earth to get it here today, but also for making the experience of producing it such a wonderful one for me as an author. I think that the integrity with which they treat the scholarship and the way they integrate kind of the practical mechanics of producing a book with your own kind of inchoate desires as an author is just tremendous. And I'm very, very grateful to Georgetown and to Richard in particular. So just a few words about the book. It's funny when you turn in the manuscript. It was so long ago. It almost doesn't even look like my book anymore. Because the ideas fade from your head. You know how this happens when you write something. So I'll just give you a little bit of a sense of what I was trying to do with it. The title of it is, if I can find my notes here, Laws, Virtues. Fostering autonomy and solidarity in American life. And it very much arises out of, I guess, my long-standing interest in integrating the study of theological ethics in particular and law, not seeing them as two separate disciplines, one over here and one over there, but as really moving continuously from one realm into the other. How does somebody who looks at the world through, in my case, a Catholic Christian perspective, think about living in law or living in a pluralistic liberal democracy such as the United States? What are our obligations? I think there are many ways that law and morality, or the study of theological ethics and the study of law, can interrelate. As I've moved on in my study, I've seen ways, and I'm now working on ways in which actually law can infuse theological ethics with some ideas. But that's somewhat of a different project. This project is sort of thinking, well, if you think of something as moral or immoral, should it be legal? And how do you think morally about the relationship between morality and law? So it's much more focused on that straightforward question, which drew me to the integration of law and ethics in the first place when I was actually a graduate student at Princeton. Paul Ramsey, the great Protestant ethicist some of you may have heard of, said to me, if I were going to do it again, I'd get a law degree too. So this is for him in some ways. So the title of the book, Laws, Virtues, Fostering Autonomy and Solidarity in American Life, in American Society, is premised on is taking seriously the idea that law can have a pedagogical function, a function as a moral teacher. And that comes very much out of the Thomistic understanding of what law is. It's very much a Catholic understanding more generally. In some Protestant traditions, you see an emphasis on law as restraint. Take the Lutheran tradition, restraining people from doing bad things. And then there's the theological function of the law. It convicts you of doing bad things so that you're driven to grace. In the Roman Catholic tradition, there is much more of a sense of the positive function of law as leading people to virtue. One of the functions of law overall is to lead people to virtue, although different kinds of law, as St. Thomas says, do this in very different ways. When we're going to talk about human law. But what I think is really, even in interpreting some of the debates that are going on now, the very neuralgic debates in the culture wars, I think bringing some of this to the forefront is a good thing. There's an optimism in Catholic understanding of both the capacity to understand moral norms and the capacity to transform people so that they can actually straighten up and fly right, so to speak. And that's rooted, I think, in the Thomistic, I call it a practical mysticism almost. For St. Thomas Aquinas, what natural law is ultimately is the participation of the human mind in the eternal law, which in some way is equated with God himself. So, your process of reasoning can't go totally wrong, really. It can go pretty wrong. Aquinas is not, no Pollyanna, because you're reasoning within the context of the divine mind. Grace itself, when he talks about the relationship of law and grace, is a communication of God's own self to you. It's a participation in the life of God. So the optimism in the Catholic tradition is both, about reasoning and about God's relationship to us. And I think that very much informs, if somebody's looking at like our bishops, and you don't have to agree with what they're doing on every point, but are out there saying, well, we can do this, we can here's a voting guide, look at this is good. Part of that is rooted in, a very Catholic sensibility about how God relates to people through law as well as through grace. So that's just a little bit of a background to say why you think law can be, pedagogically even have a role at all. That's out of the Catholic tradition. One of the points of law, then, is to lead people to virtue. Even human law is to lead people to virtue. It leads people to the virtues that are appropriate or that are valued in the particular society. They don't necessarily have to be virtues absolutely. Aquinas talks about how they're going to be virtues that are appropriate to a particular society. So the point of Nazi Germany was to make good Nazis, even though Nazism wasn't good in an absolute sense. There's a pedagogical function of law. I argue in the book that the virtues we should think about, and I guess this is my kind of constructive bit on the theoretical framework, that we ought to think about in our pluralistic liberal democracy, fostering the virtues of autonomy and solidarity. But of course those words are very vague. How do we understand autonomy and solidarity? And I suggest, it's mix and match, you draw your thoughts from where they come. I suggest that we draw our understanding of autonomy in conversation with the great perfectionist liberal legal philosopher Joseph Raz from Oxford, who wrote a book called The Morality of Freedom. And he's what's called a perfectionist liberal. And what he says is, negative freedom from is important, but it's important primarily to foster freedom for, so that people can be the part authors of their own lives. It takes seriously human dignity as connected, not in every single case. You've got hard cases around the edge of the very handicapped, the very young, and the very old, but as normally exercising, their practical reason in making some choices about their lives and being the part author of your life. You can't be the total author of your life. If I could be the total author of my life, I'd be 5'10". I am not. But you can be the part author of your life. And for Raz, what that involves is sort of three kind of basic components. One is basic material, well-being, food, shelter, basic education, nurturing. You gotta give people that. Second, freedom from coercion and manipulation. You can't treat somebody as a pure means and expect them to come up as a part author of their life. And then thirdly, a reasonable range of morally acceptable options from which to constitute their lives. You can't just give them one thing they have to let it lead into, but you can't expect to say that, being a part author of your life requires an infinite range of options. So, some little boys I've met want to become medieval knights. They did. And unfortunately, the social structure that supports medieval knighthood is no longer available. Yeah, I know, it's sad. We feel sad. But we don't, you can't say that somebody doesn't have autonomy because they don't have that option. So those, I think, are what it means to be autonomous. And I think that dovetails nicely, now I'm bringing in my theological side, with some things of what John Paul II has written about solidarity. The sense that we, in a sense, are all really responsible for all, that we have an obligation not just to promote our own well-being, but also to find our flourishing in promoting the well-being of others. You know, that is part of what's at stake. And what hits me is that promoting autonomy, as Raz understands it, is a social project. It's not a project that you can just do on your own. Societies have to be committed to providing the education, the support, the training to children. You know, we train, you know, children in our society to make choices, right? Little choices. You know, which dress do you want to wear today, the polka dot or the striped dress? What do you want to eat, the Fruit Loops, or do you want to eat the, you know, the Lucky Charms? Well, I'm the aunt, so that's the question I give them. Not the, you know, do you want to eat the Wheaties or the, you know, granola? So those are focusing on that, I think, kind of says we are committed socially to raising people to exercise this autonomy, understood not as radical freedom of choice, but as being a part author of your life. Theologically, I don't get into this in the book, I would say, well, in order to discern your vocation, you know, in conversation, in connection with other people. I argue, I don't go into huge detail about that, but I do argue that in our society, at least, autonomy and solidarity can be understood as specifications of the virtues of prudence and justice, you know, respectively. Part of practical reason, part of developing the characteristics of practical reason in a Western liberal democracy means being able to be a part author of one's own life in this way. And part of justice, part of what we owe people is enabling them, you know, to participate in a highly complex society organized in that way. So those are what I think are the two overarching virtues, not the only virtues, that you know, a Western liberal democracy, centrally the United States, needs to try to inculcate. But those aren't all of law's virtues. And the kind of the key point of the practical aspect of the book, if I can find where it is, okay. This is my summary of what law is. It's a passage from Isidore of Seville that was quoted by Thomas Aquinas. Law shall be virtuous, just, possible to nature, according to the custom of the country, suitable to place and time, necessary, useful, clearly expressed, lest by its obscurity it lead to misunderstanding, framed for no private benefit but for the common good. Now notice in this list of law's virtues, you have some pointing to substantive virtues. Law shall be virtuous and just. But you also have all of these other virtues of good law that are highly practically oriented. Good law isn't an abstract thing. The virtues of good law are not limited to inculcating good virtues. They also have to take into account all of these other factors. And part of what the book does, you know, an overarching, I guess, purpose of the book is to try to figure out how we deal with the first part of the virtues, you know, inculcating autonomy and solidarity, and in the context of a situation which are very complex in a liberal pluralistic democracy, where the custom of the country, suitability to place and time, necessary and useful, clearly expressed, all of that are really difficult factors to take into account. So I'm trying to argue that good law has to really pay attention to both of those at the same time. And then I go on to try to show, first off, in the first two chapters, how it might do that. My central example in the first chapter is, you know, I basically try to suggest that despite of all our fights, we do have a pedagogical function of law in the United States, and it can be read as fostering autonomy and solidarity. I use the Americans with Disabilities Act as a way of kind of showing that, which I think is an extremely important piece of legislation in our society. I contrast it with the message of well, the ugly law, it was called. It was on the books in Chicago and other cities in, into the early 70s. And it was a city ordinance that said no person, of improper appearance shall present themselves on the city of Chicago without, kind of incurring the penalty for a misdemeanor. So if you were a handicapped person, if you were disfigured, if you were in some sense unable to kind of present yourself normally, you were supposed to be invisible. Now, what message does that send? Pedagogical message. And I contrast that with the message of the Americans with Disabilities Act, whose first point is it's not called the Disabled Americans Act, it's called the Americans with Disabilities Act. Americans more important than disability, which is all about trying to include people of different abilities in the society. But it's not just the great big vision, the moral vision that's operating. What you see if you closely analyze the Americans with Disabilities Act is an attention to what's reasonable, what's possible, what's according to the custom of the country. So if you're building a new building, you have to make it handicapped accessible. If you're substantially renovating, you do. But you don't have to go in and tear down your, 300-year-old church, or synagogue or mosque and make it accessible if you can't do it. You have to make reasonable accommodation if you're an employer in hiring somebody. So if somebody can do the job with reasonable accommodation and they've got a disability, it's an otherwise qualified person with a disability, you have to hire them. But you don't have to restructure your whole office so that you can make room for them. It'd be nice if you would, but you don't have to. It has to be reasonable in terms of the accommodation. So I try to suggest that if we do look at American law, not just as, setting a neutral vision of our relationship with one another, if we try to look for what we have in common, there are many examples where we're inculcating a vision of morality that we agree with, that we're committed to, but that we treat reasonably. And so that's kind of the model, for what I try to do in the book. We can talk more about the details, but I start off with the sort of easier case, and then I go on and talk about various non-controversial issues, such as abortion and what a pedagogical function of the law would do with abortion in a society where we're divided about it. Genetic information, and it's called Razi and Autonomy, and I'm hoping to work with Tom Banchoff and the Science and the Human Person part of the Contending Modernities project to expand this. I don't know if you know this, but the human genome, we pretty much understand it's been mapped, and we're figuring out what some of the genes do, but we're not really good at figuring out what they're going to do exactly. What we've got is probabilities for what could happen to you. And now Walgreens and other places have tried to sell direct-to-consumer tests on this. And the question is, should they be selling them? And I actually argue, probably not. This isn't going to help autonomy, given the state of the tests and also given what's called the low numeracy of Americans. We are terrible at dealing with probabilities. We have no idea how to analyze them, how to use them, and a lot of that information is in many ways misleading. And then I go on and talk about assisted suicide. So I've got that section of the book after the theory that deals with abortion, genetics, and assisted suicide. And then finally, I go on and talk about, what does it mean to vote? How do we think about voting in the context of autonomy and solidarity? And I do this in dialogue with the bishops' faithful citizenship and some of the critiques that have come up about why Catholics should vote. Some people say, well, you've got to vote on abortion because it's an intrinsic evil, and I say that doesn't quite work that way. Or cooperation with evil contributing to the wrongdoing of another. You've got to vote because you don't want to cooperate with evil. I say that doesn't work that way either. So here's how to think about it instead. And if you want a brief capitulation of the voting chapter, Commonweal this week has, kind of a short excerpt from the chapter on voting. So my goal in this, overarching my existential goal in this, is to try to find a way to think about law and morality in a controversial, on controversial topics in a way that's deeply rooted in the Catholic tradition, which I think is nuanced and interesting on this, but that doesn't devolve into culture war battles, to try to take seriously what it might mean to have a moral view that you're advancing in a society where other people have very different and equally held moral views, and not to try to do it in terms of relativism or a harm principle, but of saying here's what I think is the truth, but here is how far the law can go given what the culture is. So I want something that's not relativistic. I'm not a moral relativist, but that's realistic and that's respectful of other people's viewpoints. So that's kind of a summary of the book, and there are some good footnotes in there.
Well, great. Thank you for that, Kathy. I have one sort of more general abstract question, and then a few more specific things that I wanted to ask about that I think would let you elucidate particular points you make in the chapter around particular issues. So when you point to Isidore's passage about law, it does seem to set up, in some ways, bipolarity between moral realism and moral idealism, in particular about how we legislate about particular issues. And you say in the second chapter, and I quote, "I argue that wise lawmakers must balance moral realism and moral idealism in formulating law for the communities for which they are responsible. They are making law for ordinary men and women, not saints. Consequently, the limits of the law must be the limits of ordinary virtue." Now, I found that particularly striking for setting up a lot of what you try to do in the later part of the book. It also reminded me of something that H.L.A. Hart said in his very famous essay, Positivism and the Separation of Law and Morality, which many people read to be a sort of frontal assault on any conception that morality has anything to do with law. And he says, like nettles, the occasion, you'll have to look that up, the occasions when life forces us to choose between the lesser of two evils must be grasped with a consciousness that they are what they are. And it strikes me that one possible critique of your overall framework is that you set up this distinction between moral realism and moral idealism in a way that comes down for the moral idealist to look too much like moral realism, if not just realism. And so I wonder, just as an abstract theoretical question before we get into specifics, how you would see yourself differentiated from some of these other positions and where you see yourself on the spectrum.
Okay, that's an interesting thing. Well, I guess I'm not, what I want to do is make good law. And what I want to say is that good law always has to take into account the people that it's directed at, because law is an action guide. Fundamentally, for Aquinas, law and grace are two external principles, but law is an action guide. So it's not meant just to be a pretty picture up there. It's meant to be an action guide for a particular group of people. So the best analogy I can give to this is sort of exercise. If you take somebody who's been a couch potato for 30 years and then stick them in a marathon, they're gonna die and they're gonna rebel. Well, they're gonna rebel or they're gonna die. They're not actually going to get better physically because you're starting too high. or at a level that they can't go along with. So I think law made for a particular community, in order to be good law, has to be something that people can do, in terms of the basic requirements. But law is more than just the basic requirements. It has an orientation towards some way. It's bringing you along. It's putting you in a certain direction. And I think you see this very much in these big, like the Civil Rights Act has a vision of the community. The Americans with Disabilities Act has a vision of the community. So it's pulling you along towards something that is better, and that it's not just leaving it in the realm of adiaphora as something that you can do or not do. It's saying, we need to be getting here, but here's how we're going to get there now. And law itself isn't one thing, and Michael knows this, and actually, practicing lawyers know. You got the criminal law, which has got really hard requirements, right? You do or don't do this, or you go to jail. But then you have a whole bunch of civil measures that can be used to pull people along in direction. So you might say, if you discriminate on the basis of race or disability, jail. You do something really hard. But there can be a civil suit for other kinds of failure to comply. There can be an injunction that's brought in to make you comply. We can give you tax breaks and incentives in order to push you along that spectrum. So I think what we have to think about is law isn't any one thing, and it's got a message, and it's pointing in a particular direction, and it has a whole range of tools other than just criminal prohibitions in order to get us there. So I think there's a big difference, and I talk about this with abortion, we can talk about this later, between saying, well, the line on abortion that I always found most troubling was by William Brennan, Justice William Brennan, in which he wrote in one of his, I think it could have been a dissent, it could have been a concurrence, when stripped of its sensitive moral connotations, abortion and childbirth are simply two different ways of ending a pregnancy. No, they're not. They're not just two separate ways of ending a pregnancy. And you can't strip moral connotations out there. Saying that is a very different thing from saying, in a very complicated society, we don't have the resources or the right to kind of prevent pregnancy or prevent abortion very early on, and we don't want to put women in jail, and we want to encourage childbirth, but we do think, generally speaking, childbirth is a better outcome. We're not going to prevent it through the criminal law, but we're going to encourage it by other means, by making it more effectively possible for women to make that choice. So I think you can look at law not just as what it prohibits or permits, but as what it encourages, and say, just because we're not prohibiting it doesn't mean that we don't think there's a better choice here. Another example, far less controversial, home ownership. It's not intrinsically evil to live in an apartment, right? It's not. As far as I know, that's not on the Pope's. The Pope himself would be in big trouble if it were. But in the United States, we do a lot to encourage people to buy homes through the tax code, because we think this creates stability in the community, responsibility for the community, a greater tax base for the public school systems. All of that's part of moral pedagogy.
Yeah. So you already anticipated my next question about abortion, and you argue fairly convincingly, I think, that the model of law as police officer has, for the most part, consumed the debate on abortion. Both sides sort of accept that model, and you propose law as teacher of virtue as a different way to advance the conversation. And I think you anticipated some of those arguments. You spend a chapter talking about the Freedom of Choice Act controversy, and I wonder, how does that law as teacher of virtue model apply to that, and what lessons do you draw for how the conversation could move forward from that 2007-2008 controversy?
Oh, okay. Well, I mean, do you all remember the controversy over the Freedom of Choice Act? All right, the Freedom of Choice Act, the controversy came up in Obama's first presidential election, and I think and it might have been the summer of 2007, he spoke before a Planned Parenthood group and said, the first thing I'll do when I'm president is sign the Freedom of Choice Act. And then that was picked up by the, kind of traditional family values people and the Catholic bishops, and saying, oh my God, this is the most radical law in history, and he's going to sign the, Freedom of Choice Act. He's the most pro-abortion president in history. Don't vote for him. And it was a big controversy in the Catholic press and actually in a lot of the other press over this. Well, what I did was, when this was all going on, I went and actually printed out the actual bill. And the bill reads, I'm going to be somewhat insulting here, excuse me, but it's true. It reads like it was written like at 2 o'clock in the morning by a bunch of pro-choice activists who, had had 1 or 2 beers, maybe too many. And why do I say that? Because if you look at the bill, which is just 4 pages long, I think, it's got all of this. Well, the freedom of choice is the most important, virtue. We've got to protect women's access and women's this, and the right to abortion is really important. We're going to protect this against all encroachment. So you've got the preamble to the law, which goes on for like 3 pages, and then you got and the actual operational provision was like about a paragraph. And we'll change the law to do this. So it wasn't actually a law, as I read it and as I looked into the history, meant to be a law. It was a bill that was proposed as sort of a political statement. And and if you want to see a law that was meant to be a law, that's going to have wide and sweeping effects, take a look at the Affordable Care Act. Over 1,000 pages long. How's it going to change the tax code? How's it going to change the ERISA code? How's it going to change Medicare, Medicaid provisions? How's it going to change, all sorts of things, So that's what a bill that's meant to be operationalized looks like. Very short on, drama, and very long on provisions that make lawyers rich. So I said, well, what is this meant to do? It's meant to be a political statement, and it actually functions really well for both the pro-life community and the pro-choice community, ironically enough, because the pro-choice community hold it up as a rallying cry, and the pro-life people point to it as, kind of a counter-rallying cry. Look how extreme this is. But when you actually try to work out, well, how would it operate? And I did the best I could. I honest to God did. And I couldn't at some points because they were saying, well, it was going to overturn Casey, but it sort of upheld, kind of said nice things about Casey, so it wasn't clear it was going to do that. It presented itself as if it were, kind of not just a statute, but a super statute, almost like a constitutional amendment. But it's just basically another law, even if it's enacted. And a law, you can't make a super law that trumps other laws. So if the Hyde Amendment, which prohibits funding for abortion, is passed after it, or even if it's still online, you've got to reconcile these 2 pieces of legislation. And, how would you go about doing that? I thought there were even constitutional problems with it because, it could run afoul of the Commerce Clause, and I actually think the constitutional problems are stronger after the, the opinion in the Affordable Care Act. So I said, doing this isn't a good thing. We ought to learn from this, because your pedagogical function when you're trying to teach with the law is actually undermined unless all the other things that Isadora talked about, clearly communicated, suitable to place and time, according to the custom of the country. If all of that is messed up, that's going to inevitably mess up your pedagogical role, because nobody's going to understand what it is you're trying to teach. And the fear of the law exceeding its bounds is going to really create more opposition from the people on the other side. And so I used a piece of pro-choice legislation for that, but the point is general. It would apply to a piece of pro-life legislation or any kind of badly worked out law on any controversial topic.
So the last question, and this builds perfectly on what you were just talking about, but at the question at a level of constitutional law, you turn in talking about euthanasia and well, particularly with assisted suicide, you turn to two cases, Washington v. Glucksberg and the Quill case. And as I read you end at a place of somewhat comfortable with the way the court ruled in Washington v. Glucksberg, where they ruled that there was no constitutional right under the Due Process Clause to assisted suicide. Washington had a statute that said that you could not engage in assisted suicide. Physicians could not assist and that sort of thing. And you turn to the argument that this old saw about the laboratory of the states, that letting the court stepping back and saying, we're not going to decide this for the entire nation. We're going to affirm the fact that states can decide this legislatively and politically among themselves within constitutional parameters is probably a good thing. And that seemed to gel with your quoting Isidore and the concern for sort of the local manner and custom to some extent, and which fuels the capacity of the law to be a teacher of virtue. So I guess I'm interested to hear more about that argument. I have strong disfavor for Washington v. Glucksberg, I think for reasons that relate to this, in the sense that the way the court does an analysis about due process really limits what can count for an unenumerated right that can be protected under the Constitution. I guess in the end I'm fine with where you come out, that this particular one might be better done legislatively and politically at the state level, but this doesn't solve the problem. It just sort of pushes it down to a more local level, and then you have different schemes in all 50 states and territories. So I'm curious how you would sort of address those issues.
Oh, okay. Well, I mean, I do think there are issues with Glucksberg, on other levels, in terms of how they describe the rights. And for people who are interested in the religious liberty question, here's a freebie. In Glucksberg, what the Supreme Court said is, well, you have to carefully describe the right that's at stake here, and it has to be narrowly circumscribed, because when we're dealing with constitutional rights, it has to be narrowly circumscribed. So the pro-euthanasia forces were saying, well, this is the right, to die with dignity that's at stake. Big picture right, blue, white, red. You can imagine the staging for this. The Supreme Court in Glucksberg said, it's not that. It's the right to end one's own life with medication prescribed by a physician. That's the rights at stake. So you took the big picture right, you defined it very narrowly, and then the court said, you don't have that very narrow right. If that's the procedure that's used to analyze the religious liberty cases, my guess is the people who are very supportive of Glucksberg are not going to be very supportive of, a redescription of the right in religious liberty as, the right not to contribute money that may go, someplace down the line to pay for contraception. So when you think about how you're dealing with particular cases, you have to think not just about one case, but how this analysis you're framing is going to apply in other situations down the line. So I mean, that's another one of my worries about how these religious liberty cases are actually going to fare. But that's as I said, that was a freebie.
Yeah.
I generally think that on highly controversial issues, involving kind of, values on both sides, that they should not be constitutionalized, too early to settle the debates, really. So I think Roe v. Wade, at the time Roe v. Wade was decided, was a mistake. That it stopped the country from having the debate it needed to have about abortion, and it stopped the country from having the flexibility it needed in kind of working out a legal regime that would be appropriate. And remember, Roe v. Wade doesn't just bar the states from doing it, it also bars the federal government, so the people on a level from doing that and responding to new information. So those kinds of decisions, just on a jurisprudential issue, I think ought not to be settled at that level. I think that what Quill and Glucksberg did in saying the Constitution says nothing about assisted suicide was in fact the right way to handle the situation. I don't think that the Constitution itself handles how you treat a very very difficult situation, that much of the time arises because of some of what's come up because of modern medicine. And so we have different states, different small communities trying to deal with it and dealing with it in different ways. Right now, Washington State and Oregon and Montana have legalized it. There's a fight over legalizing it in Massachusetts. I don't know how it's going to go. But if you lose the fight in the states, then you can go back and fight again. You can take the data, you can bring things back, you can revise, and you can learn. And I think that on very hard questions, I call them remote applications of the principles of natural law, that's the way they should be handled. I also talk about in here, which might be controversial for some more conservative Catholics. I say I actually have a higher opinion of Justice O'Connor than some of my colleagues do. I think that she doesn't have necessarily high theory, but she's got a lot of practical wisdom. And what she says is, one place that, the prohibition of assisted suicide we're not going to allow to reach is when it comes to a shot or medication to stop severe pain while dying. Nobody has to die in extreme pain. Now, you might say, well, Catholic thought in terms of the principle of double effect covers that. If you're truly giving a shot to end the pain and not to kill the patient, even if the foreseen immediate and unintended consequence is killing, is shortening life, you're not actually intending to kill, so it doesn't count as euthanasia. And my view is, yes, I agree with that. I totally accept that. Unfortunately, the legal statutes of many states aren't written in a way that makes that totally clear, that sometimes the immediate effect is seen as the intended effect. So by her saying this, I think you're actually stabilizing the system in a way. But in terms of the jurisprudence, and the whole historical jurisprudence, I think there are problems there. So I'm really focusing more on the result. But I agree with you.
It's interesting to bring up Justice O'Connor because as a legislator, she was a state legislator before she became a jurist. She's often pointing out when Justice Scalia is saying, let it go to the political process, don't constitutionalize it. She's often the one to point out in concurrences or dissents against Justice Scalia that, in fact, we have to deal with this at a constitutional level. And I always wonder if that's because she recognizes sometimes the legislative process can yield a tyranny of the majority rather than protecting minority rights on these issues. So, well, with that, I'd like to turn it open to other questions so we can expand the conversation.
So the last thing I would say about the book is that the book is black and white, but I guess most of the book is arguing there is no black and white, so it's kind of an irony there.
It's the red in the middle with the hands held.
Yeah.
I knew what they were doing. If you could just introduce yourself too.
Yes, well, I'm Roger Trigg from Oxford. I'm just interested in what precisely you mean by autonomy here and how far you push it, because I think for some liberals autonomy is actually the right to decide for oneself what is right and wrong, and so the very idea that the law itself is saying I should bother about solidarity, for instance, would be anathema.
Yeah, that's an extremely good question, and in the first chapter of the book I spend a lot of time talking about the difference between that kind of liberal, and I use Joel Feinberg's 4-volume series on the moral limits of the criminal law, a subjectivist account of value, and I contrast that with Raz, who is a perfectionist liberal. So the autonomy I'm talking about, I hope I made clear in the book, is very clearly not of the kind that you're talking about. I spend a lot of time critiquing that account.
I'm John Borelli. I'm here at Georgetown.
Longtime friend.
Longtime friend, and I do recommend the article in Commonweal that Kathleen has authored with regard to the history of the bishop's advice on, the history of the bishop's advice on political engagement, let's put it that way. Kathleen, who would be arguing similar points as you on these virtues and the law and government and society, but from an agnostic point of view? You reach for solidarity into John Paul II, and I'm sure Catholic social tradition. Are there those who are parallel with you, good interlocutors, but would not be drawing from a theological faith?
Well, I don't know. I mean, I haven't seen a whole lot of virtue theory moving into law, but I stopped reading at the time I, was starting to write this. The Aquinas, what really focused me on this was, that Aquinas passage, that about how to, deal with all the different virtues. But I think there are people who care about this, who, on the, well, Raz himself is wonderful. The Oxford Jurisprudence School, and you can tell me, really I think is very much in, kind of in the Raz Dworkin kind of debate about liberalism. I haven't seen anybody really push it more toward virtue theory yet, but they're all profitable and wonderful people, to read. But Michael might have. Can you think of anybody that's doing? But he doesn't do it virtue.
Out of an American context.
Now then, I think you're kind of stuck with me.
Hi, Tom Banchoff. I'm director of the center. Kathy, it's great to have you here, and congratulations on the book, which looks terrific. You don't shy away from controversial issues in here. Maybe you could say a little bit about a current controversial issue. How would you approach the issue of same-sex marriage within your framework?
That one, yeah, I haven't approached it within the framework because I was sort of dealing with the life issues. I think I would approach it in much the same way. I think constitutionalizing it is going to short circuit a debate that we need to have about what marriage is. I expect that's what's going to happen is there are going to be some states that are going to permit full-blown gay marriage, and I think that will probably move up the protections in terms of civil unions. And then what we're going to be arguing about really is what the goods of marriage are. I think probably within 10 years the baseline will be some sort of civil union, and then the argument will be over whether it's called marriage. That's what I think.
Let me rephrase and make it a little more difficult. What about generally debates about equal civil rights for homosexual Americans in all dimensions, not just the marriage dimension?
Yeah, I guess what I would say is, this is what always ends up being the problem, right? It's not all dimensions per se. I think the hardest issues are when it comes to children, and I think the actual hardest issues are when it comes to access to gametes, artificial, oocytes and artificial insemination in order to produce children. On the other side, I think, I myself think that's not going to be a hard issue. I think people are really moving in that direction. Where I see the difficulty coming in, and it's also a scientific difficulty, is we are pretty much the Wild West out there when it comes to artificial reproduction in terms of, homosexuals and heterosexuals, and I don't think you can restrict, for homosexuals, access to those, to these techniques of artificial reproduction. What I'm wondering is whether we really need to rethink some of those techniques with respect to all, you know, parents that are engaging in them. So that's where I see the big rub coming in, not in the social acceptance, you know, frankly, not in the sexual morality, because I think our sexual morality is past that, but what is the relationship in, you know, on a common level, not, you know, what is the relationship of children biologically to socially? How do we think about that? Now you've got 3 parents in California. You've got your, you know, 3 natural parents. How do we think about parenthood? That's where I think the rub is going to come.
Just to follow up again, trying to link it back to your framework, you hit on a very controversial and difficult issue. Is this something for the law, where the law will have a pedagogical function, or are we in a pre-legal phase where we should just be talking about it?
Well, I don't think it's one or the other. I think we're in a legal phase on, you know, employment discrimination, on, you know, on kind of housing access, on, you know, on all of those issues. On what happens to children. I mean, I've been worried somehow when you see the results of some of the data about people wanting to know their biological parents. You know, so maybe we need to think about, well, is there other forms of open adoption we can make available? Are there other ways of, you know, making sure that, you know, people have some access to that information about who created their, you know, their genetic makeup, particularly since so much of medicine is now going to be tied to that. The other thing I think we need to think about, and I think this is a conversation you need to have, is what do we think about having people of opposite genders responsible for kids? You know, do you need both sorts of role models, and how can you find ways of having access to that if you're a same-sex couple? So those are conversations. You can't force them. But those are the conversations I think we need to be having. So I'm not in favor of, you know, tamping down by, you know, constitutional amendment or otherwise amendment preventing this. I think we're in a very chaotic situation here, and that's pretty normal.
Hi, Sarah Brent-Hudgens. I work for the Berkley Center. I like your idea when you're talking about not wanting to end the debate too early, especially on social issues that people have very strong feelings about. But you mentioned earlier about the idea of the justice's idea in the role of preventing tyranny of the majority and protecting minority rights. Right. So how do those two play in, for example, Roe versus Wade, or on an issue like same-sex marriage, where in the long run having that debate might be healthy collectively and get us to a place where everyone's more content and the law protects people, but in the short term, people who feel strongly about those issues might be saying, you can talk about this for another 30 years, but I can't do something that I believe is right.
Right. I mean, and I think that is a tension in the law. Any kind of moral development in the law is going to take going to take some work, really. I mean, and the problem with, abortion, same-sex marriage is harder because there's not clear justice implications there. You know, for people who are pro-life, there's another being involved, so it's not quite clear what the law should be. I mean, because you've got to protect this other being. And for women, and I think you can see this, abortion is a difficult situation because there is no other situation in the law where one person is required to provide bodily life support to another person. So how we balance these concerns and these rights, is not something that we can, work out in a day or two if you see the full complexity of the situation. Law itself is never going to be stable, and I think this is another thing, if it's not according to the custom of the country. So whether you like it or not, you got to move the custom along. You've got to move the moral consensus along. If you read Aquinas on this, he says, well, positive law trumps custom. It's like rock, paper, scissors. But in the end, Lizard Spock, that was from the Big Bang Theory. So Spock, the one that sits on top of it all is custom, So if you pass a law and it doesn't change, the custom, then in the end, the custom wins. So you have to be able to move the law along, move the people along enough so that they're going to accept the law. You know, you saw that in Prohibition, it didn't work. You saw that in the first set of civil rights acts that were passed right after the Civil War, crashed and burned. The Republican, you know, yeah, well, we won't go there, but, you know, just was completely undermined because there was a backlash against what was going on. So my view is you have to take seriously the pedagogical function of the law as moving things along in a way that's for ordinary people, not for saints. You don't start the marathon, it's the kind of couch to 5K program for moral and social reform. So yeah, people lose.
If you were writing a chapter about this, you might have another chapter about the Prop 8 debate in California, because you see precise parallels with Roe v. Wade, where even in the time that the state cases were being shaped, the opinion polls opened up a 10-point gap to the other side. So it was 48%, for gay marriage and civil unions, and now something in the order of some in the 50s, in the upper 50s. Right. And so there was a debate about whether or not to then move forward with the federal case, which David Boies and Ted Olson pursued, because it would challenge this, constitutionalize it, and then create potential backlash when the opinion poll was moving in the right direction. So.
Yeah, there's no substitute for the hard work of changing minds. You know, I mean, there's no short circuit on any issue. I mean, you just have to try to convince people. You have to expose people to your point of view. And I actually trust in that. I do believe in the development of doctrine. I do believe people's reason is, in some sense, connected to the divine. We get it wrong a lot, but I believe that there's a possibility of moral transformation in people. So...
here's another kind of issue. My name is John Warren. I'm with the press, actually. And I think it's interesting, your idea of the law kind of pushing or encouraging good behavior. And I'm wondering about the issue, you know, we have a kind of obesity epidemic and sort of a junk food epidemic. And there's this movement in New York to ban large sodas. And I kind of wonder what you think about that, and also how far that might go. If it was up to me, I might ban McDonald's, but I don't think a lot of people would agree with that. But you know, how far can the law go in these things? You know, to say, you know, you can't eat junk food or something.
Well, I think banning. I mean, that's what I mean. I think there are a lot of tools. Banning is one thing. Encouraging is something else. So I think there's a lot of room for the law to encourage you to, you know, to do things, you know, that pertain to your health. You know, banning, you know, I don't think is justified in this instance. But I'm actually not a big banner of a lot. I mean, I actually think demand side. Is much better to focus on than supply side. So, you know, if I were writing a much longer book, like part 2 would be, you know, the drug wars. You know, what are we doing with marijuana? You know, who's in jail because of all of this? You know, Prop 8, all of these more, you know, social issues. I focused on the life issues because it seemed to be a way to kind of keep the book within some limits. So, we didn't need a magnifying glass. But those would be issues, I think, as well. So I'm not in favor of outright bans of things like that, because I, in the end, don't think they work very well.
So last question.
Okay, great. Alyssa Devlin, no affiliation currently. Off of your response to the last question, you know, you're saying, how can we address these issues practically? So what would your answer to, say, issues like birth control, where there's, you know, a lot of religion questions regarding that? How would you do that practically? What would be the 5-kilometer step for the person headed to the marathon from the couch, like at the grassroots level?
Where's the couch? I mean, what's the couch?
Your analogy, the couch.
No, potato. I know. I'm just trying to figure out. Well.
Oh, I see what you're saying. Well, I would say.
You mean on the Catholic side, like traditional Catholic side?
I would put the marathon as your personal point of view, as, you know, where you think the law should be headed.
Well, I on birth control. I studied under John Noonan, and I myself think that view, you know, holds. So I don't believe each and every act of sexual relationship between a husband and wife has to be open to, you know, to children. And I certainly, so that's my own theological view. I certainly think the broader American society has reached a kind of moral consensus that, you know, birth control qua birth control within the context of marriage sexual is not immoral. So now, if I were, you know, if I didn't hold that position, if I held, you know, kind of the more conservative Catholic position, the magisterial Catholic position, actually, the teaching of the church, how would I approach this issue? Well, I guess what I would say is the first thing I'd try to do would be to try to get an NFP covered within you know, the Affordable Care Act is part of the range of things that's covered. Why not? If you, as I read the Catholic literature on this, that they say this is actually better and works better for women, and people who are taught it will find it works. Well, the first thing you got to say is, well, let us give it a shot. You know, maybe we can change the consensus by making this open to people to, you know, to see. So I try to argue for a plurality within the things that were covered. The second thing I would try to do is to try to make common cause with, I think you're going to find a lot of more progressive Noonan-like Catholics who are really worried about, you know, the hookup culture and the morality of what's going on there. Is, you know, to say that, you know, John Noonan, I am quite sure, would not approve of Jersey Shore. You know, I mean, yeah, it would give him a heart attack. So, you know, how do you, you can talk about sexual morality more generally and find common ground without necessarily agreeing on that one point. I'd like to see more conversations about that. Thirdly, this is where I think we Catholics get messed up a lot. We love the pedagogical function of the law. Love it. But we're not as good about another important function of the law that I haven't come up with a one-word description of, but I call it the mess cleaning up function. Law creates incentives, and law tries to minimize the mess in people's lives when people are behaving badly. So needle exchange programs, all sorts of programs like that. You know, the debate over the HPV shot. I'm surprised, you know, that the people opposed to contraception in the healthcare plan haven't opposed the HPV virus shot, because, you know, if you actually behave sexually strictly, you're not going to probably get HPV. And what they're saying is this counts as an incentive to bad behavior. So I think we need to separate in looking at the contraception and the law question, both, you know, what actual sexual morality is, and then what do you do in a world where nobody accepts that in order to minimize the mess. And that's analogous for me to needle exchange programs, to condom provision, to all of this. It's to minimize the human mess. And we need to separate those two questions, in my view.
All right. Well, thank you, Kathy. I encourage everybody to pick up a copy and read it through and join the dialogue. So thank you.
Thank you for your questions. That was very helpful.